This is the second year in a row that Ron Ciotti is here. He's going to scare you to death. I mean, he's very good at that. But I do want to say personally for Ron, he's a construction attorney. He's a total expert. He was recommended to us by Lou Migliori, which we appreciate. And when anybody calls me and asks a contract or advice on some kind of problem they're having on a job, I always call Ron on his cell phone, and I would tell you 9 times out of 10, he always answers. And the second thing is he calls the member back right away. I don't know of any other attorney that's ever done that, which I think is awesome. So I'm going to turn it over to Ron, and we appreciate you being here.
Thank you very much, Jeff. Jeff, before you leave this stage, for those of you guys who know me, you know that I work with a significant amount of associations and organizations. And I get to work very closely with the executive directors of those organizations. And I will tell you that I've gotten to know Jeff now for about 1.5 years, maybe 2 years. And I've gotten to work with Jeff on several different issues and questions that he's had. You guys have what Jeff brings to you, his energy, his professionalism, his passion. It is extraordinary. You're one of the best executive directors I've ever had the pleasure of dealing with.
Oh, thank you very much. Thank you.
Yeah, baby.
I appreciate that.
Thank you. So my name's Ron Ciotti, if you haven't noticed from all of the different things on the boards here, in Jeff's introduction. I'm an attorney with Hinckley Allen, and I will introduce myself every time as a construction attorney with Hinckley Allen. And the reason I bring that up is because I have a very significant issue with attorneys who represent themselves as construction attorneys. And then you go to the website, and they're listing construction, banking, general commercial litigation, a whole plethora. I'm assuming that if somebody represents themselves as a flooring contractor, they do flooring. They don't do a little drywall, they don't do a little framing. So when you're looking at an attorney, and I'm not trying to just sell my services because there's more of me out there that just does construction, make sure you are hiring a construction attorney. My firm is Hinckley Allen. We're about 250 attorneys. I'm not sure where we're at right now. We have offices throughout the country in Boston, New York, Chicago, Providence, Hartford, a bunch of other offices as well. But the biggest thing about our firm is not our size as far as the overall attorneys, because there's a lot of firms that are larger than us. It's the size of our construction group. We are one of the largest construction groups in the nation. We do our work all over the country, and we do our work all over the world. And it gives me a great understanding of the industry. It's all I do. It's 100% of my work. Right now I have cases in 20 different states and 3 different countries. It is a wonderful, wonderful way to practice because I get to get intimate with the construction industry and know you guys and know all about you guys. And in fact, the most recent thing that happened to me that I was really pleased about is the fact that Wentworth Institute of Technology in Boston asked me as an attorney to be an adjunct professor in their construction management program. And I thought, an attorney in construction management, wow, these guys are whacked. But anyway, it was very nice. And I do a lot of this because I really enjoy the educational components to construction law. And in fact, next Tuesday, I'm speaking at the AGC National Convention, yes, the general contractors. And next Thursday, I'm down actually in Orlando at the World of Modular speaking there. So next week is a little crazy for me. But I'm here today, and I'm really excited to be here today because I've fallen in love with your organization, and it's been a truly, truly pleasurable existence, the way I've gotten an opportunity to know your membership, and a true honor and privilege for me to get to work with some of you guys. And I'll tell you, it shows in the fact that who you guys are and what you guys are, because look at this. We're in Palm Springs. It's 80 degrees right now outside. It's sunny. And you guys are in a windowless room listening to an attorney talk about contract provisions. So I love you guys. You guys are fantastic. So the reason that we're here is to talk about contract clauses. But I will tell you, before we do that, how many of you were here last year for my presentation? Show of hands. Oh, that's great. You guys came back. Wow. I really, really don't trust your judgment. But anyway, the reason I bring that up is because is there anybody in this room who remembers please tell me there is, what I spoke about, what the topic was last year? It was material price escalation. And the reason I bring that up, material price escalation, is because of the fact that I was here to talk about a few different ways that material price escalation can happen that were meaningful right then and there, which was taxes, tariffs, trade wars. Tariffs certainly are still an issue. And I even threw in the fact that it can happen relating to natural disasters. What I didn't touch on was material price escalation can also happen due to epidemics and pandemics, which hopefully is not what we will get into here, but we certainly have some epidemics going on within certain countries. Now, those countries, luckily, like South Korea and China, don't have any link to you guys in any way. They don't manufacture any of your products. Oh yeah, they do, don't they? So the fact of the matter is, I hope that each of you took what I said last time about material price escalations, and remember those material price escalation clauses, day one, threshold, delay clauses? Hopefully these are bringing back some memories. And I want you to think about that. And I want you to hopefully realize that what we talk about in here is important to bring back to your businesses, because if you have a material price escalation clause in your contract right now, you're going to be fine if there are supply chain interruptions and delays in the materials. And not only the delays and supply chain interruptions, but what does that do to usually the price of those material goods? You have supply and demand. You cut off the supply or you have an interruption in that supply chain, price goes up. You don't want to be stuck in that. So hopefully you have a material price escalation clause, but we also talked about the force majeure clauses that are in most construction contracts. Force majeure is nothing more simple than extraordinary circumstances that occur that are outside of your control, like an act of God or an epidemic or pandemic. So those should be looked at, those should be used. I will tell you, we are already experiencing some delays on projects due to the China interruption in the supply chain, not so much in flooring yet. But we have already experienced it in other projects, and we are using those force majeure clauses for those clients who haven't put material price escalation clauses in. So if you haven't, go back to my PowerPoint from last year and steal those clauses that I gave you last year and make sure they're in your contracts, okay? So that was last year, but the question I have for this year is, do the contracts you're using, do the contracts you're signing on your projects, do they facilitate success? Or do they cause more adversarial positioning than is needed in a project? The other question I have for you, for those who have really good eyesight, is do you actually read your contracts? Do you know what's in them? And I hope everybody in this room says, I absolutely do. Because if you don't, you have no idea what the playing field is. So this is one of the quotes that I really like from the Construction Industry Institute. It talks about really in this industry that really needs coordination and teamwork, we have this adversarial industry, which is really sad. And what the Canadian study showed just recently was that exculpatory clauses in contracts increase the price of that project by 8 to 20%. So why would we want that? Why would owners want it? Why would GCs want it? Why would anybody want it? And it's because of the fact that everybody digs in and decides, I got to protect myself. And that is not good in an industry that relies on teamwork. Even Einstein had a rule of construction contracts. Obviously, I'm being facetious, but it's the definition of insanity in doing the same thing again and again and again and expecting different results. Now, obviously, that's what we're doing here because we're using the same darn contracts that we've used for years. They don't work. They're adversarial. Somebody in here the other day had a great point, and they said, it seems to me that contracts are getting more adversarial. They're getting tougher. They're getting worse. And the answer is that's correct. But I will ask you to look at yourselves when you say that. Because when you get a contract, if you're one of the many, many, many people, probably one of the 80% that just sign it because you don't feel that it is appropriate for you or a good idea for you to go back to the GC with revisions because A, you'll ruin the relationship, or B, they're not going to take it anyway. Those are incorrect. I work with a lot of general contractors, forgive me, but I do. And the fact of the matter is, we don't look at your revisions as, okay, on to the next subcontractor. We came to you for a reason. We wanted you to do the work because of the quality that you bring and the professionalism you bring, and we want your number. So when you say, I can't do that, they'll just go find somebody else, it's not that simple. And when you say, I'll ruin the relationship, you know what I say? That's chicken. Mike Moore said the other day that it's human nature not to want confrontation, not to want to have that difficult discussion. That's what you're doing. When you're saying, I don't want to mark this up to make this a fair contract because I don't want to have that confrontation, the answer is no. They're going to respect you more, and I will tell you now, I have been on that side. They will respect you more. There is a small percentage of them, you're right, that will say, no, it's either my way or the highway, and I question whether they really should be on your high list as a client. But the fact of the matter is, you need to understand and you need to have confidence that if I mark this up, I'm going to be able to negotiate the terms of this contract. So I came up with, and I don't know how to go back on this, so I will not do that, but I came up with Ron's top 15 killer clauses in a contract. And it's really important to understand what these 15 are and how I came up with them, because of the fact that within these 15, these are 15 that are in most construction contracts. What I mean by most, I'm really talking about AIA, consensus stocks, DBIA, EJCDC, some of the form contracts out there, because it's impossible for me to know all of the manuscripted contracts, and obviously I do, but guess what? Guess what 90% of the manuscripted contracts have? Stolen clauses from AIA, DBIA, EJCDC, and consensus stocks, because that's all their attorney ever dealt with before they wrote that contract. So when they wrote that contract, they just stole provisions. So most of these you're going to see in those contracts. So the first one is notice requirements. And you might say, well, that's not really even a provision within the contract. And if you say that, you're right. It's not. Notice provision is not a clause in the contract. It's numerous clauses. Because notice provisions are throughout your contract. Notice provisions are within the areas of claims, changes, cure periods, differing site conditions. There's a number of different areas, and each one of those has different notice requirements. Why am I so hyped up about a notice requirement? Because if you miss it, you lose. And when I say miss it, I don't just mean the timing of it, which is the first thing you should know about notice requirements, is the timing. The second thing, how to give it, what form. Is there an actual form? Is it written? Is it oral? How is it allowed? How is notice allowed for that specific area, whether it be claims, changes, cure periods, etc.? The next, who do I give it to? Because you might hand it to a project manager. That should do it, right? Project executive, that should do it, right? Maybe not, because the contract might be specific as to who all notices have to go to be accepted and approved. So the fact of the matter is you need to know the timing, the person it needs to be sent to, the form, and also you need to understand how that needs to be delivered. Because in delivery can be everything. I just talked about hand delivering that notice to a project manager on site. It says in the contract I can give delivery to the project manager. I gave it to him. I handed it to him. That's not good enough, because that's not allowed under the contract. The contract specifically says it needs to be delivered by courier, or it needs to be delivered by certified mail with return receipt. And guess what? I'm not just picking that out of thin air. AIA in 2017 changed their notice requirements for claims in their general conditions in their AIA A201. And they changed it to just those two delivery methods. Hand delivery between parties is no longer accepted. That's absolutely ridiculous. But that's what it is. And guess what? If you have a viable claim and you deliver that by hand, I gave it to the person that was to get this under the contract. And they're going to look at you and say you didn't accomplish notice properly because you didn't give it by the delivery format that was outlined in the contract. So what I always ask you to do is when you have a contract, go through that contract. You got to read it, but go through that contract and look at those notice provisions and create a form, a spreadsheet, an easy-to-utilize spreadsheet of all the different notice requirements within that contract, and then hand it out to the project manager, the supervisor, project executive, so that they understand it. The people that are most likely going to be giving that notice, they should be the ones that get that, because they're probably not the ones that are going to go through that contract in detail, nor do you want all of them reading that contract in detail. That's called not time useful and cost efficient. So that's really what you have under the notice requirements. The next one is incorporation by reference clauses, probably the most dangerous of all clauses within a contract. How many of you have ever dealt with an incorporation by reference clause? Ever had it in your contract? You all have. You all have. Because an incorporation by reference clause is in every contract whereby what it does is it takes the prime contract and incorporates it into your contract. And it will also have language with it in the normal circumstances and the common usage of this provision. It will have language that states you are taking on the obligations of the GC to the owner. You are taking on those obligations that are within that prime contract. Now, only those that apply to your scope of the work. But those are obligations that can be very, very hefty. And if you didn't see that incorporation by reference clause, or more importantly, you saw it, but you didn't ask for the prime contract, I will tell you, out of the hundreds, and yes, I do mean hundreds, of cases that came into me last year, I will tell you that I would say less than 5 of the subcontractors I talked to, when I said, can you send me the prime contract? They said, we don't have a copy of it. I said, did you ever get a copy of it? No, we haven't gotten a copy. Did you ask for a copy of it? No, they wouldn't send it to us anyway. What do you mean they wouldn't send it to you? That's part of your contract. So here's what I will tell you on how to handle incorporation by reference clauses. Add to the language of that incorporation by reference clause, which is found in every single standard form construction contract. Add to the language that It is only incorporated by reference if the general contractor provides you a written copy of the prime contract in all of its parts prior to the execution of your subcontract agreement. You should have the opportunity to review that contract before you execute your contract. So please add that in there to yours, and then make sure you actually get that copy and you review it before you sign your contract, because you may not like what's in there that you just signed on to. So make sure you get that and make sure you follow that. The next one is pay when paid or pay if paid. And by the way, I'm going to interrupt myself here for a second. I'm just hammering away because we got a lot of material to cover. But as we go through this, it is much more helpful if I know what your questions are as we do. So please, I talk quick, Jeff and I have something in common, but the fact of the matter is I need to know what you don't know or what you want to know. So please ask questions as I go through. Just raise your hand or shout it out or whatever you want to do, but it makes it much more interactive that way, and I think much more educational. So please, by all means, do that. So the next section is pay when paid or pay if paid clauses. I bet you guys love these, don't you? These are one of the most unfair provisions in a contract. In fact, I always say, if a provision is not even allowed in some jurisdictions, is voided in some jurisdictions, doesn't that kind of tip you off as to not being a particularly fair provision? Pay when paid falls under that category. In a lot of states, in their prompt pay acts, pay when paid clauses are deemed invalid. I don't know, you're all from all the way across the country. I've dealt with almost every prompt pay act in the country, I think probably everyone, but couldn't probably tell you off the top of my head unless I just recently dealt with it. But if you call me, I can certainly tell you whether your prompt pay act in your state relates and invalidates pay when paid clauses. But pay when paid clauses should be either stricken, if you can. I would start off with asking for it to be struck. If it is not struck, your backup to it is to request a timing position. And what I mean by that, and the reason, by the way, they have been struck in so many states, is because there is an unfair, there's actually public policy behind it. Because here's the issue. The GC wants the relationship with the owner, right? You guys want the relationship with the GC. The GC wants a relationship with the owner. Your work, for whatever reason, hasn't been paid by the owner. And so now we're looking at it saying, okay, well, the GC is sitting there saying, well, I want to be friends with the owner. The owner hasn't paid me, but the majority or all of the payment that I'm missing goes to this subcontractor that I don't have a relationship with. Okay, Mr. Owner, I'm going to make you happy. Don't pay me for it. You can't sue me. I'm the GC. I got a pay when paid clause. The owner didn't pay me. And I just made the owner really happy by telling him don't pay me. And now you can't pay me. Then you can't sue me for it. So I made the owner happy on your back. Sound like a fair clause? No. The answer is no. So don't be signing pay when paid clauses if you can. Strike them if you can. If you can't, put a timing provision in there that says basically a pay when paid clause ends up basically expiring after a certain amount of days. Whatever you can live with there. I don't know if it's 90, 120, whatever you guys can live with, but you're giving the GC some time to work it out with the owner. But if he can't work it out after a certain amount of time, the pay when paid clause expires and you are owed your money. Okay? So that's something to think about. I just heard a comment. Yes, back. It certainly would take care of the last provision relating to if you have a clause in there that says you can suspend work for non-payment. It would take care of the last bullet here. but it would not take care of the second, which is still trying to get you paid. So by not working, that could get you paid, but it's not a guarantee. I want a guarantee by having that pay when paid provision expire after a certain amount of time. So that's pay when paid. I'm going to skip payment terms because it's a pretty straightforward bullets there. But I want to talk about retention. Ross.
A GC that agrees to strike the pay when paid.
Striking not often, but sometimes. Agreeing to a time period on it, almost always. Okay. Because they understand the fact that you can't just sit back forever and not be able to sue for not being paid. You need a timing aspect to that when that expires. And it does put some pressure on them. It makes sense from a public policy. It's a hard argument for them to come back to. Retention is an interesting one here because this is such a different animal in the commercial business. And I don't mean commercial construction business, I mean in the commercial business, period. In the commercial world, we don't have retention. The construction industry has retention. And just like everything else, you know what falls down. And this one falls down to you guys. Here's the problem. Why is that fair? Because let's think about what retention is for. Retention is to allow the owner to take what his project and be able to finish it if you can't finish your work. And to make sure he has enough money to finish it. So the example I'm going to give you is you have a $100,000 flooring project. You've reached 50% completion. Owner has paid you for that $50,000, but you can't complete it at that point. So the owner needs enough money to go back out and finish that job. He's got $50,000 left on your contract. That should be enough, but we all know that replacement contractors cost more than the original contractor in almost every case. So he needs that sliver, that additional amount to be able to complete that job. He doesn't need a huge amount, he needs the sliver. So is having 10% across the entire project a sliver? No, that's you guys financing the project for the owner and the GC. It's you guys. Congratulations, you know you're a bank? So the issue here is we need to change retention, and we are. In the industry as a whole, we are. Where we've come from, it was always 10%. That was completely unfair. We have now gone to what is more common, 10% that drops to zero at 50% completion or 5% across the whole contract. We are now pushing because of the fact that even that is too much really for an owner to be able to utilize that sliver. And so we're now looking at it and saying where we should be pushing this is 5% for the first 50% and zero after that. And we're pushing it, by the way, from both subcontractors and general contractors. Because the one thing you have to realize is that your contract is probably not going to be better in the retainage area, meaning less retainage held, than the GC's, because that means the GC isn't getting paid for you for a portion of the your work that he has to pay you. So that's probably not going to happen. But again, what is the GC's retention? Well, the GC's retainage is going to be found where? In his prime contract. Another reason you need it, okay? Got a question?
Mike, is it working? Okay.
There you go.
In my company, we always, at 40 to 50% completion, try to get a 50% retainage reduction. There's constant pushback. So that you're saying at 50% to go to zero, where is that happening? Because I'm not feeling that in the industry yet.
It's only happening through GCs that are willing to push that with the owner. Because you're not going to get a better deal than the GCs have, just because they're not going to want to pay you out. The issue is, and we've been talking about that at the AGC, the Associated General Contractors of America. I'm heavily involved in that organization. And I will tell you that that is one of the things that we've been discussing and trying to push. And the more we get general contractors to push that with the owners, the more we're going to be able to carry that up the chain. But you should never have a worse position than what the GC has. There is no reason if the GC has 5% across the board or 10% with 0 at 50, that you should have 10% across the board. Or any situation where you're having more retainage held than the GC should be the same, so that that cash flow continues right through. So now we get to indemnification, another fun one and another unfair one in the industry. Indemnification has come a long way, but not even close to enough. This is the A401 AIA's subcontract agreement. This is the indemnification clause. And I highlighted in red a certain section of it that I just find actually somewhat comical. It's not comical to you, and I understand why, but I think it's absolutely ridiculous. Because why are flooring contractors agreeing to indemnify the architect, the architect's consultants, and the architect's agents? You know why? Come on, somebody's got to have it, right? Because it's an AIA contract. It's the Architectural Institute of America. So why not have your members indemnified by everybody? Anybody take a guess as to, and I want a hand here, anybody take a guess as to whether or not in the standard AIA contract the architect indemnifies the flooring contractor? Not going to happen. So the first thing that should be done is you should strike that. I don't ever get pushback on that, because the GC has no love lost for an architect, and I will tell you that normally the owner doesn't really care either. So that should be out of your contract. Then, yes? What's that? The
prime contract, would that
if
supersede that?
If it's been incorporated into yours, you have to specifically exclude it within your indemnification. The next, and that's a really good point, because it is in the A201, unless the GC came to me and we wiped it out of the owner contract as well, the prime contract, because there's no reason why a GC should be indemnifying the architect. Next is reduce your indemnification by the percentage of your fault. We should not be in the age of broad-based indemnification anymore. Well, I told you we've come a long way, and most indemnification provisions now understand that. And I've quoted here Consensus Doc 750. Has anybody used any of the Consensus Docs documents? Fantastic documents. They've come out of the AGC. I'm really biased here, and I admit my bias because of the fact that I am the chair of the AGC of America's Contract Documents Forum, and that's the forum that is in charge of drafting Consensus Docs. And Consensus Docs is now a form family of construction documents, over 100 documents in 40 different organizations, and we're looking to fuse to join. 40 different organizations have signed on to these documents. They basically go through every organization in the industry. And they're really much more fair documents, as you can see even by this indemnification clause provision that I quoted here from the Consensus Docs 750, which is the subcontract agreement for Consensus Docs. It limits your responsibility in indemnification to your percentage fault. So if you're 20% at fault, if you're found that you're 20% at fault for that actionable issue on the project, you should not have to pay more than 20% of the indemnification. And even more importantly, you should not have to pay for more than 20% of the attorney's fees, of the defense costs. Where in most of the indemnification provisions that are out there right now, you do have to change this, because you can get held for all of the defense costs, even if it limits the indemnification part of it to your responsibility, your percentage responsibility. You should also look to reasonable attorney's fees. That allows a judge to actually, at the end of the case, or an arbitrator, to actually look at the attorney's fees that the other side amassed and determine whether or not they're reasonable, because your indemnification only obligates you to pay for reasonable attorney's fees. So change that. Make sure that you have in there the reasonable attorney's fees portion of it. But make sure in your contract that you are limiting your indemnification to just your percentage, including the defense costs. Finally, I want you to think about a mutual indemnification clause. And most of you are probably with your mouths open right now. No. The GC only the GC indemnifies those above him. The subcontractors indemnify those above them. Why? If you make a mistake on the project, you need to indemnify the GC, right? Okay, that makes sense. If the GC makes a mistake on the project, shouldn't they be held to indemnify you? Seems fair, doesn't it? Because that's what we're really after. We are after a fair contract. Now, some of you are going to say, well, the GC's never going to go for that. You know how they'll go for that? Their own documents. I just told you that the AGC of America drafts consensus docs, right? And nobody knows that better than me because of my position with AGC. Well, I will tell you, we have put in mutual indemnification clauses. So when your GC in your locale says that's absolutely ridiculous, quote the AGC. Quote their own organization, their own documents, and I'll smile on your behalf. Mutual indemnification is where it should be. So next is consequential damages. This provision scares me because in all the years I've been doing this, and it's way, way, way too long, consequential damages has killed more companies than any other provision. If you waive consequential damages on every project you do, you are rolling your company's dice. Because consequential damages, anybody know the difference between actual and consequential damages? So actual damages versus consequential damage. Best example I can give you has nothing to do with flooring. Site contractor operating an excavator swings that bucket way too fast, way too wide, hits a wall, collapses that wall that was just built on the project. That's actual damage. When they rebuild that wall, the cost of rebuilding that wall, that's actual damage. The consequential damages was shutting down the OR that was on the other side of that wall and shutting it down for 2 weeks because of the damage that you ended up causing inside that OR. That's the consequential damage that you now run into. Which one was more expensive, to rebuild that little wall or the shutdown cost of an operating room at a hospital for 2 weeks? It's massive. So you made a mistake, you knocked down a wall, you got a few $1,000s to fix that wall, and you've got millions of dollars in consequential damages for shutting down that operating room. So the fact of the matter is your margins are too small. You cannot afford to take on consequential damages in every project. Absolutely cannot, on any project. And so there is a standard waiver of consequential damages, but there is also a trend to watch these get struck. I have watched owner after owner and GC after GC strike the waiver of consequential damages. That should be a non-starter for you. Don't accept it ever. Next, and by the way, even if you strike it, check the prime contract, because you still may be on the hook. You're going to have to put in some specific language in yours to exclude it. So the next is LDs. LDs to me is one of the most creative and one of the most interesting animals in the construction industry because they're so misused and they're so misunderstood. First off, liquidated damages are not supposed to be, surprise, surprise to everybody, are not supposed to be a punitive damage. They're not supposed to be a punishment, right? You guys probably did know that. I assume you did know that. They're not supposed to be a punishment. They're supposed to be an estimate of the actual damages that would occur if there was a delay at the end of this project. And so when you're on that project where you can't even figure out if there would be damages by just having a week late delivery, and yet you look at the contract and it's $10,000 a day in liquidated damages if you're late, that's called a punitive clause. and it's not allowable anywhere. So understand what liquidated damages are for. They are to give an estimate of what those actual damages would be. And then understand that you can't get, and I've had GCs use this on my clients, where not only do we have $1,000 a day in liquidated damages, but we've got all of these lost rents, all of these, and pours on all these other costs. No. You don't get both. You made a choice at the beginning of the contract when you put in liquidated damages, or when the owner put in liquidated damages and you passed them on to the subcontractor. You made a decision at that point that you gave up, you waive your actual damages, and you are now limited to your liquidated damages. So you have to understand that that's what that LDs are, and you can't get hit for both, okay? So when somebody tries to hit you with that, know that they are bluffing, because you can't get hit for both. Now, the one thing I will say is that they also are one of the most oddly used provisions in a contract, or misunderstood, because I've had a lot of my contractors say to me, Ron, I'll never sign a contract with LDs in it, never. And I look at them and go, why? I want to ask you that from a business standpoint. Because think about what LDs do for you. You can now calculate whether or not, what's the best decision forward, what's the best financial decision forward. And the example I'll give you is, you know you're going to be a week late on the project. From an LD standpoint, you knew you had LDs of $1,000 a day. That's $7,000 for that week's delay, okay? I now look at it and say, how much is it going to cost me to accelerate? It's going to cost me 20 grand to accelerate to get done on time. What am I going to do? I'm going to take on the liquidated damages. I'll finish a week late. $7,000 versus $20,000, usually in my book, wins. So the fact of the matter is, that's how you can calculate. If you don't have liquidated damages, it doesn't mean you don't have damages. It just means now that week late, you don't know what the damages are. You don't know what those actual damages, because if they don't have liquidated damages, then they get what? They get actual damages. So now you're in a situation where you don't know how to calculate it. You're looking at it saying, I got $20,000 in acceleration costs to finish on time, and I don't know how much that delay damage is going to be if I miss the date by a week. So I better finish. So you're unable to make that calculated decision. So that's why it's so important. Scope of work. Next one. I know this is not a provision in the contract, but it is one of the more important aspects or parts of your contract. Because what I see a lot of times, and you will be blown away by what I get to see in contracts, I have seen contracts that have said on million-dollar jobs. I mean, in fact, I saw one, the worst one I probably have ever seen, was on a $75 million job, and the site contractor had the entire site contract. And that site contract, I don't remember the exact amount, but it was a massive amount, came to me and said, I want you to read this over. And their scope of work, you know what it said? Complete all site work for project. I'm looking at it going, how are you going to determine changes on that? How are you going to determine differing site conditions off of that? It is so crucial to be as detailed as you possibly can within your scope of work, and to include something else that I should have included on this slide that I did not, and I should have. An exclusion list. Be detailed. You need to tell them what you're not covering under that scope of work. So you should have a standard exclusion list within your contract if you don't prepare it now for your contracts. And make sure you update it for each project. And then put it in so that that scope of work is not mistaken to include what you normally exclude or what you want to exclude on this project. Scheduling. So the next thing is scheduling, and what I'm going to say very quickly about scheduling is know that it is your obligation. I've had contractors tell me, well, it was a schedule, but that's not part of the contract. And I said, what do you mean it's not part of the contract? Did they not give you a schedule when they hired you and you signed the contract? Oh, I knew what the schedule was, but it wasn't part of the contract. I said, what do you mean it wasn't part of the contract? Is it incorporated? Is it part of that contract? Well, it wasn't in the contract itself. Well, no, that's part of the contract. And if you know that schedule, then make sure you understand it and you look at it as gospel. Now, what I will also say about schedule is be realistic. I have the most cases I've ever had in my career right now on projects that relate to subcontractors who have literally said to me, Ron, we should have never taken this. I knew at the time this came in that we couldn't meet the schedule. We didn't have the manpower because we're in a workforce shortage if everybody doesn't already know that. The fact of the matter is you need to be realistic. There's too many jobs out there that look great, look sexy, look wonderful. I want a piece of it. But when you realize the schedule for it doesn't fit your manpower, don't take it on, because that's what leads to massive delays and real big issues and much more costly legal fees relating to your delay that you knew you were going to have when you took it on. Next one, standard of care, real quick. Standard of care. I've seen too many contracts. It's a new, and the reason I put this in there is it's sort of a new trend. I've seen these standard of cares being upped by owners and GCs to this standard of excellence. Do not allow that. First off, you might void your insurance, and that should scare everybody here. But secondly, you're not going to be able to meet it. You should always use just industry standards, and so do not do not allow for these heightened standard of cares that are now seeing their way into construction contracts. Next is lien waivers. This is one of my favorites. This is I think one of the most important ones here. So if you've fallen asleep through so much of what we've done so far, please wake up. This is really dealing with three different issues. The first one is where contractor provisions requiring a subcontractor to waive liens before the work is performed is added into your contract. Do not sign those. Why would you waive your right to a lien before you started your project? And if that's what they're requiring, do you really want this project? And I will tell you that it falls within the fairness category again that I spoke about before. And that is that if it's not allowed in most states, that should send really a big red siren signal to you saying, this isn't a fair provision. And yes, in a lot of states, those are not enforceable. So make sure you get that. Requirements next is relating to those provisions that force you to remove liens by either paying them off or bonding them off. This is a major issue as well because of a couple of things. One, it's not good for the project because you may be having a supplier or a subcontractor of yours who either did poor work or provided poor materials, who placed the lien, and now you're being forced to actually pay them for those poor materials or poor workmanship. Real problem there. Secondly, the fact of the matter is if you're going to sign a provision that says you're going to bond off or pay off a lien, then make sure that it accepts out non-payment by the owner of the GC. Why should you have to pay for a lien that's brought by one of your subcontractors or suppliers who didn't get paid because you weren't paid by the owner of the GC? So non-payment by them should be an exception to this provision. It should be out. So then finally, and I've had this utilized, is somebody saying when you brought a lien on the property, them saying, oh no, there's a provision in there that you have to bond off or pay off that lien. Your own. That's pretty circular, isn't it? Let's make sure it doesn't happen. So accept out your own liens as well. And I think we had a question back here.
With this provision and another one that you had brought up before, you had mentioned that it's not enforceable in all jurisdictions.
That's correct.
If it's not enforceable in your jurisdiction, does it matter if you sign it anyway?
It does.
And then you avoid an argument and they can't enforce it anyway?
It does not, correct. As long as it doesn't get changed. But the fact of the matter is you can sign that, and if it's not enforceable under the law, it's useless. Now, I don't think that's best practice. Best practice is always to get out useless provisions and make a contract fair and as streamlined as you possibly can get. But if you want to avoid that sort of give and take, I would actually just say to them, because it makes you look better, that I understand the law and I don't think that's allowable. Let them go, oh, he knows his stuff. Next is review partial and final lien waivers. Now, here's the reason I bring this up. This has come up a few times over the last couple of years in some big cases for me. You get these final and partial lien waivers in, which you sign regularly to get your payments under your pay apps, okay? Well, let's say in pay app number 4, they withheld 50% of that pay app because of a disputed item, and they didn't pay you on it. They paid out 50% of pay app number 4. Pay app 5 comes now. You've sent in pay app 5. It doesn't include pay app, the disputed number, because you put that in as either a claim at this point or in some other way are still disputing that issue. And so payment 5 goes in, and guess what? You sign a lien waiver. And that lien waiver says you've been paid in full up to this point. You may have just waived your right to that 50% on pay app 4. I will tell you, we are in a $4.2 million dispute right now where my client had provided additional work under change orders, hadn't been paid for certain work, but continued to sign lien waivers through the entire project. $4.2 million of work that he may have waived. So we need to be very cognizant of that. Make sure that you specifically accept those, if you haven't been paid, any type of claims that disputed amounts. Yes, sir.
I got 2 questions. Not sure if you're going to get to these, but OSIP, the Owner-Controlled Insurance Program.
Yeah.
And then perhaps for the folks in here, what remedies might we have with some of the manufacturers who have fallen down and delayed shipments and put us in positions potentially of having to delay a project?
I'll take the first one and say OSIP is a huge. I've only got 2 minutes left, so I'm gonna bypass the OSIP question. But the one on suppliers and materials, we really get into, and in fact maybe I should just shift there anyway, because I think that's probably going to be your most significant one is warranties. Really, it's going to be under the warranties, I think, where most of your battles are going to take place with your suppliers. And here's what I have to say. It came up the other day that said warranties basically don't cover anything, and they accept out everything. Well, I do have a problem with warranties. First off, the supplier warranties, and I apologize for the suppliers in the room, but the supplier warranties, for the most part, don't even cover what is the most significant piece, which is not just the material replacement, but the demo and the reinstallation costs and the moves and everything else that has to take place based on the fact that the materials weren't appropriate. Lou knows this. We're in the middle of a very large case at the New York Times building where we've got about $2 million right now in total damages. Very, very small percentages in the material. Very, very small. And they're willing to change the material out, but that's it. We need to start paying more attention to the fact that warranties express are contractual, but the implied warranties on a manufacturer are these down here in the bottom left-hand corner. Manufacturers are under the UCC, not common law. You guys are under common law. They're under UCC. Under the UCC, there are implied warranties of fitness for purpose and merchantability. The fitness for purpose is a significant one and may cover you as a breach of warranty if those materials were faulty. The express warranties that come with the product, we need to do a better job in fighting back against. And you guys need to do a better job in your warranties and making sure that you're not warranting your labor in a different way than what's implied under the contractor impliedly warrants that its work is performed in a workmanlike manner. I don't think you would. But here's one of the things that I've been asked is, can we limit our warranty in some way if we find out that there is moisture-related issues? I'm not a big fan of limitations of warranties because of the second bullet I have, or third bullet I have up here. First, it is going to be difficult to get a GC to sign off that that your warranty doesn't cover if it's found that there is moisture in the subsurface. The second bullet, or the third bullet, is the most important, that most jurisdictions are not going to allow a contract that comes after an agreement that comes after the contract in a separate document that unilaterally changes those terms to be valid. And so I would recommend that instead of a limitation of warranty, we look to indemnity. We look to indemnity agreements for those specific terms. And we look to indemnity agreements to both the GC, the owner, and the supplier. And that's where it comes back to your question, sir, is we should be looking to the supplier to indemnify for those issues and holding them responsible for it. This is a much larger subject on warranties. I'm going to be around the rest of the day today. And I will tell you that what I'd love to do with you guys at some point in the future, if Jeff will allow, is I saw lots of curious faces through this. We had a lot of material to get through, but I'd love us to have at some point in time more of a town hall setting where we just discuss these issues, and you guys can hammer me with all the questions that you can ever think of, come loaded with books of questions, and we can have a great discussion. That's what I really like. That's what I really want. Today we were sort of moving at 100 miles an hour. We sort of strap on the seatbelt and let's go. Hopefully these helped you with the understanding of what we should be doing. But have the confidence. Hold the GCs to it. Make the changes in your contract. Make them fair. That's where we're going. I'm telling you, you will get through more than you ever imagined. So I really appreciate your time, and I really, by the way, it's a privilege to be here. It's a privilege to have had Jeff ask me, and it is an absolute privilege and an honor to represent so many of you in this room. I thank you very much.
Thank you, Ron. That was awesome.
Thank you.